I live on Hickory Grade Road. I'm the last house in the township and the county. I totally understand where these young ladies are coming from as far as concerns about their family, but my statement tonight comes from my heart and from living in this township most of my life. I've been a resident of the township most of my life, and I've seen many changes over the years. Monaco Manor was built in my backyard. I wasn't happy about that. Route 50 was built right through Cecil. Western Center was turned into South Point, and the Southern Beltway is going to be built approximately a half a mile down the road from my home in South Fayette Township. And this is all for progress. And the reason this township is such an awesome place to live is because of the progress and where we've come today. And that's fine. That is why I think we do need the compressor station built on 980 in order to move the gas. Without the compressor station, our progress and growth as a township will be stunted. No more appeals, no more court costs. We need to stop spending money on legal fees and put the money towards improvements on our township roads. Many of you know my family and have heard our requests over the years to have Harmon Road paved. Our requests have been repeatedly ignored, and when Hickory Grade Road was to be paved this spring, we received nothing but patches. Nothing. As a resident, I would like the compressor station approved, eliminate the legal fees to stop the compressor and our growth of the township, and pave the roads in our township. Thank you.
Mike, just 1 second. Sure. Before our meeting this afternoon, or this evening.
Can't hear you.
Before our meeting this evening, we got an email from the solicitor which he has agreed to do this, to appeal on behalf of the board pro bono at no cost. So before that comes up, you know, over and over again, that will be
whenever we voted in December of 2013, this was whenever the first appeal was coming up, okay? Because Mark West had appealed this to the Commonwealth Court. John, you went and we gave you permission to go and attend that hearing, and you did that all free of charge also. It's in the minutes. You can pull it up in our December minutes. So you didn't...
I thought that neither Gateway nor John Smith were permitted to be involved in any oil and gas litigation or anything to do with oil and gas.
The Gateway, they recused themselves on some of the buildings in South Point where they've engineered them, where they've done the engineering on them.
Yes, because you wouldn't allow them.
no on a case-by-case basis. I'm saying they recuse themselves on a case-by-case basis, not as an overall everything related to oil and gas.
You weren't a supervisor at the time.
But that's irrelevant.
You weren't head. And at that time, in a meeting, it was determined, and Andy led the issue. Gateway should not be involved with anything to do with oil and gas. And more recently, the same thing happened with John Smith, and I don't remember just how it came about, or your law firm, John. I'm not sure.
You know what? It was the we hired special counsel for the impoundment at my request because I had a private lawsuit against Range for another impoundment. So I thought the board should have outside counsel.
And that was the only issue on it?
Actually, I'll read it. I have it from Monday, December 2nd of 2013. Motion 22-2013. Motion and a second that Mr. Smith represents Cecil Township regarding the Mark West appeal of the zoning hearing board denial for compressor station on Route 980. 4 of the 5 supervisors in attendance voted aye. Super Cotton voted no. Mr. Smith added that he would not charge for travel or attending the argument. That's in the minutes. Anybody can pull them up on the website. Okay. Mike, go ahead. It's your turn.
That's all I was going to say. No, actually, John, you kind of inspired me. I had a few comments, but now I have to take exception to a couple of things you said. And one of the reasons...
Can you all hear him in the back?
Actually, I'll give you my name. I'm Mike Monaco, 1440 Rising Road. This is about the compressor station. I wanted to make sure that we discussed it, which quite obviously we are. One of the questions is why isn't it on the agenda, since it seems to be a very complex and important matter, and want to reserve judgment to be able to talk. If you do discuss it on the new matters for this meeting, I want to be able to continue this discussion. One of the problems that comes to mind is when this originally was brought to the board, and the gas industry and how these things were going to get confirmed and dealt with, it was passed down to the zoning board because the supervisors didn't want to deal with the director. So
That's
now,
not correct.
it is true.
No.
There were discussions about whether it's going to be a special and allowed.
It had to do with the zoning because it wasn't lining up as a
That's not true.
zone.
It was whether it was going to be and I forget the term, whether it was going to be allowed in the township without special procedures. As soon as it went to special procedures, it had to go to the zoning board.
Well,
And my complaint was that you
Go ahead, Mike.
were given that control to a 4-member board that actually the citizens that really can't deal with. They're not elected, they're appointed, they have their own opinions.
Right, and I understand back in the day.
Let me finish.
Go ahead.
Because this is leading up to a point.
Go ahead.
Because one of your comments was that this appeal, and the decision, I'm sorry, the refusal to approve this was approved by the entire board. And I actually had the pleasure of reading this, which is the court in the common pleas. And it said it was only approved by 2 members out of the 4. So 4 members did not approve. It wasn't even a majority.
What are you talking about, Mike? What's it say?
It's in reference to, at the time of the decision, the board consisted of 4, and I could read them, but there was 4 of them. Only the chairman and another member voted to deny Mark West's application.
Mike, that's a 3-member board with an alternate.
Yeah,
It says it's 4.
Yeah, well,
my
there's,
point is,
yeah, 3 members with an alternate. I'm not sure, I remember that.
this is the board, I don't know whether it is or not. All I'm saying is your determination that it was approved by everybody is not accurate.
Well, I think maybe Rich Bertiotti didn't show up that night for the vote.
No, no.
What it was, Tom?
He missed, I believe he missed 1 hearing.
Yeah, so he didn't vote. It was only 2, and the 3rd one can't vote because the alternate wasn't seated to vote out of the gate. So the 2 board members that were left, probably Frank Zuzik and George Augustine, they voted unanimous, well, 2-0. And I think Rich didn't vote because he wasn't seated for all hearings. He didn't make them all, because there was a lot. But to your first point, Mike, you're right.
How can you, is that considered a quorum?
Yeah, there's 3 members. 3 members.
There's an alternate.
The alternate.
Shouldn't it be 3 members to vote?
Well, again, back then, I think Rich sat in on the first 2 hearings, if I recall, and then missed 1. And then he didn't vote at the ultimate. But
That's really not my point. My point was...
Why is it there?
No, it wasn't approved. My initial concern was it was going to be approved by a board that the citizens had no...
Right, so I said, why would it be at that board versus...
Worse than that, it wasn't even approved by majority.
Yeah, it was approved by majority. It was 2-0, and the alternate was against it too. He just couldn't vote. But this board, back in the day, we didn't have a compressor station ordinance, and how that fell was to the special exception.
John, I really enjoy your conversation, but you're talking... You're really...
Go ahead, Mike.
I'll listen. Legalese.
I'm sorry.
And I need to get my point across. One is, I read this, and some of your comments were, you took exception to it, and I appreciate it, but there was 22 objections by the court. They basically took exception to everything that the zoning board did. So your argument that what they objected to was not documented or wasn't enforced is not correct. They tried a number of times, and they were found to be arbitrary and subjective. So now, let's go forward. The only thing the court did agree to is that the UDO they had to come back to the UDO, the special exceptions had to be dealt with, and complied with. The reason they objected to it is because there was no substantiation in the rules and regulations that they could comply with.
That's exactly right.
Which has changed as of today. Because my understanding is that we do have and can rely on procedures and policies and EPA regulations and DEP regulations that could be used to comply with. And that's my argument, because and 4 months ago or 3 months ago, we had this conversation about where to put this thing. I told you their question was, where can they put it in the township? Which again, you have to be able to accommodate their business. And their approach was that light industrial was the best location in the township. They went out of their way to try to comply. It wasn't like they tried to do it in a residential area. And that's what they have. And your argument that there is no regulation, that there is no supervision, and there is no policies that they don't need to comply with, I object to entirely.
Well, here's the...
I'd like to respond, please. I distinctly remember when, right before this hearing started, or while they were going on, the attorney for Mark West, Chris Rimkus, I'm sorry.
You're talking about this appeal? Or
No, before the hearings before the zoning hearing board, in fact, meetings with the township. And this was before I was a supervisor. But Andy, you should remember, and Tom, you should remember, you were supervisors at the time. And Frank, you should remember, you were supervisors, I was not. But Chris Rimkus said repeatedly at the meetings of the township, we went where the supervisors suggested that we should go. Now, Andy, you were a supervisor at the time. You were part of those meetings. In fact, as I understand it, they were private meetings. And you sent them.
And I disagree with that.
Oh, you didn't send them to this location?
Me and myself and Chris Rimkus had an argument about it that night too, because he was putting words into my mouth that were never there. And that's what the problem was. That's why you shouldn't go to private meetings like that, because they can say stuff about you, and it's not right, it's not what I said.
Frank, do you
it's not what
remember?
happened. And Mike, one of the things I did want
I
to
was
bring up
not a
was that
supervisor.
can I finish you?
Or Tom, do you remember the meeting?
I do.
And what's your recollection?
Indirectly, we met with Gateway, and we pulled out all the maps, and I can't say we directly steered to that spot, but the township, in general, the maps we gave them for all the industrial zones kind of steered them to that spot. So yeah, we were all involved in that meeting.
And you all steered them toward that spot,
Not to the, I said not to that spot, to the industrial zoning.
to the industrial zone.
Right. There was no place for a compression station. We couldn't find a place, and we were glad that they weren't going to challenge the ordinance and say that they're entitled to go in any zone since we didn't make a provision.
Which they ultimately did, and if you read the Commonwealth Court decision, the courts found that we were correct on that line, that we don't preclude them